welcome all of you to this Constitution Day lecture on the theme Constitutionalism, Liberal Democracy and Enlightened Citizenship. Samvidhan Divas, or Constitution Day, is celebrated in India on 26 November to mark the formal adoption of the Constitution by the Constituent Assembly. The Constitution of India was formally adopted on 26 November 1949, and it came into force on January 26, 1950. We are immensely fortunate to have with us today on this very, very special occasion two leading, pioneering legal luminaries. We have with us today Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, who will be delivering the Constitution Day lecture. We are also very fortunate to have with us today Professor Dr. Upendra Baxi, Research Professor of Law and Distinguished Scholar, Jindal Global Law School, OP Jindal Global University, who will be delivering the presidential address. Without much ado, may I now request Professor Dr. C. Raj Kumar, Founding Vice-Chancellor, OP Jindal Global University, to kindly deliver the welcome address.
Thank you very much, Upasana. I would like to, of course, extend a warm welcome to all of you to this very special occasion when we mark the adoption of the Constitution of India as we celebrate it as Constitution Day. I also want to reflect on an extraordinary speech that Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constituent Assembly, gave on the 25th of November 1949. And of course, many of us who are students of law, we recall that speech while we teach our students. But it's quite remarkable that he had this prophetic imagination about what could potentially be the future, and was very conscious of the state in which we were at that time. He talked about three critical aspects of the kind of, let's say, pitfalls that the young democratic evolution that India was about to witness. And the first was about what he called the case against revolution and the grammar of anarchy. And I quote, he said, if we wish to maintain democracy, not merely in form, but also in fact, what must we do? The first thing in my judgment we must do is to hold fast to constitutional methods of achieving our social and economic objectives. It means we must abandon the bloody methods of revolution. It means that we must abandon the method of civil disobedience, non-cooperation, and satyagraha. And then he goes on to say, when there was no way left for constitutional methods for achieving economic and social objectives, there was a great deal of justification for unconstitutional methods. But where constitutional methods are open, there can be no justification for these unconstitutional methods. These methods are nothing but the grammar of anarchy, and the sooner they are abandoned, the better for us, unquote. Of course, the second aspect of the concern that he expressed quite deeply, and many, many who believe in ideas of constitutionalism have talked about it, which is the notions of hero worship, bhakti in politics, which of course potentially leads to dictatorship. And he quotes, he says that there is nothing wrong in being grateful to great men who have rendered lifelong services to the country. This caution is far more necessary in the case of India than in the case of any other country. For in India, bhakti, or what may be called the path of devotion or hero worship, plays a part in its politics unequaled in magnitude by the part it plays in the politics of any other country in the world. Bhakti in religion may be a road to the salvation of the soul, but in politics, bhakti or hero worship is a sure road to degradation and to eventual dictatorship, unquote. And of course, the third, he made a very strong case for social democracy, where he talked about the fact that we need to, underline the principles of equality, liberty, and fraternity. So I want to say that just to, bring home the larger point, which is that the delicate, and critical and symbiotic relationship between constitutionalism, liberal democracy, and enlightened citizenship.
It gives me immense pleasure to speak today at this global virtual conference on reimagining and transforming the future of law schools and legal education, the confluence of ideas during and beyond COVID-19, organized by Jindal Global University. It is hard to understate the myriad ways in which the present pandemic has transformed our lives. Digital education, once seen as a supplementary option to traditional face-to-face lectures, has now become the primary mode of accessing education. These times have posed challenges for students and faculty alike. I'm sure many of you long to return to campus lives. I still, personally speaking for myself, miss the lectures on the lawns of St. Stephen's College under the cold wintry sun of the late 1970s. Likewise, I do miss the conversations on the Constitution over chai at the Campus Law Center, where I studied law between 1979 and 1982. The problems of the world were ours then, as they should be for all of us now. Memories bring nostalgia, in this case about unpolluted Delhi and so much more. However, these unprecedented times have also revealed our capability to adapt, to be empathetic, and to lift up others, to acknowledge our privilege, and to ask fundamental questions about the state of our society. As the pandemic raged, life as we knew it came to a standstill. The shutting down of industries, shops, schools, and factories exacerbated the stark inequalities that continue to characterize our society. They have revealed the fault lines. Cities witnessed a mass exodus of migrant laborers driven out by their employers or by the landlords. Our health sector was overwhelmed. Many students coming from poor backgrounds lost access to education. Prisons, which also host a large number of under-trials, became susceptible to the breakout of the virus, and more people were driven to joblessness and homelessness. A panoply of freedoms that we ordinarily enjoyed were curtailed to tackle this crisis: the freedom of movement, of assembly, and of occupation. Humanity will weather this crisis, but this is an opportune moment to ask ourselves some profound and searching questions about the state of our society. How, if at all, can we prevent social inequality from becoming magnified in terms of the economic crisis? How can we fulfill our constitutional commitment to an equal, liberal, and democratic order in a market-driven economy? How do we as citizens ensure that our state institutions continue to uphold our civil liberties and promises of equal citizenship in public emergencies and beyond? More broadly, what is the role of courts in the realization of liberal, democratic, and constitutional values? And what role do other actors have to play in this enterprise? How can the citizen, the most critical unit of our constitutional concern, contribute meaningfully in fostering and sustaining a culture of constitutionalism and liberal democracy? Asking these questions is pertinent as we discuss the concepts of constitutionalism, liberal democracy, and enlightened citizenship on the occasion of this Constitution Day. A charge that is often made against the Indian constitutional project is that the Constitution is an elite document. Instead of emerging from popular pressure within the society and being framed by individuals who reflected its full richness and diversity, the argument goes, the Constitution was a creation of India's political elite. The powerful ideas of democracy, reform, and equality, as Sunil Khidlani says in his Idea of India, persuaded a few outside the intellectual and English-speaking circles, and the Constitution could never rely on the support of any powerful group. This view was also shared by a few members of the Constituent Assembly. Kengal Hanumantaya, a member of the Constituent Assembly, expressing displeasure on the un-Indian character of the Indian Constitution, remarked, "We wanted the music of the veena or the sitar, but we have the music of an English band." Let us not forget Dr. B.R. Ambedkar's oft-quoted remark that democracy in India was itself a top dressing on an Indian soil which was essentially undemocratic. Dr. Ambedkar was cognizant that whilst the Constitution may be imbued with ideas of liberty, equality, and fraternity, its success would depend on how ordinary people and their representatives would work it. He poignantly pointed out, the working of a constitution does not depend wholly upon the nature of the constitution. The constitution can provide only the organs of state, such as the legislature, the executive, and the judiciary. The factors on which the working of those organs of the state depend are the people and the political parties they will set up as their instruments to carry out their wishes in their politics. Who can say how the people of India and their parties will behave? Everyday encounters of the people with the Constitution, including electoral minorities and subaltern groups, challenge the narrative of the Constitution being an elite document. It is this engagement of the Constitution that provided the basis for Indian constitutionalism to emerge. Constitutionalism has been succinctly defined in 1935 by Walter Hamilton when he says that constitutionalism is the name given to the trust which men repose in the power of words engrossed in parchment to keep a government in order. The Indian encounter with constitutionalism preceded the inception of the Constitution. The Indian nationalist movement, while radical in its normative hopes, was self-consciously a constitutional movement. As a mass movement, it eschewed violence as a means for achieving political goals or for changing the social order. In abjuring violence as a response to the violence of the colonial state, India's constitutional project noticeably diverged from the path to freedom which South Africa adopted, so eloquently spoken of by Nelson Mandela in his long walk to freedom. Post-independence, citizens interacted with the Indian state using the language of the law and constitutional structure to shape its structure of governance. The executive often found itself embroiled in litigation, and citizen interventions led to delays and changes in its policy. In the first decade of the Constitution, political conflicts found their way to courtrooms and became constitutionalized. For instance, a legal challenge was mounted against the ban on cow slaughter, predicated upon the rights to carry on trade, to equality, to property, and to freedom of religion. Rohit Day speaks eloquently about them in his recently published book called The People's Constitution. Liberal democracy in India has emerged from the anti-colonial nationalist movement. The colonial legacy in India included remains of a rudimentary statehood. The post-colonial Indian state was neither a product of an industrial revolution led by the bourgeoisie, nor a result of a revolutionary capture of power by a proletariat or peasantry. Rather, the dominant political class consisted of a middle class that was adept at power sharing through competition and collaboration. The Constituent Assembly presented itself as a guardian of national interest, which transcended sectarian or regional interests. The framers of the Constitution chose to set out the basic norms that would form the governing ideology of the state in the form of a liberal democracy. Liberal democracy is both prescriptive and descriptive. It consists of a set of political practices which include popular elections, accountable government, and majority-based decision-making. But it is also founded on a set of key principles: liberty, equality, and fraternity. The framers of the Constitution recognized that the commitment to a liberal democracy is necessary for the continuance of democracy itself. Dr. B.R. Ambedkar remarked, "What should be the policy of the state? How the society should be organized in its social and economic side are matters which must be decided by the people themselves, according to time and circumstances. It cannot be laid down in the Constitution itself because that is destroying democracy altogether." How prescient Dr. Ambedkar was. At the same time, our framers recognize that for our constitution to endure and our liberal democracy to survive, the state must fulfill its duty of ensuring an equal distribution of resources and welfare for all. It has to eliminate institutional and societal barriers imposed on individuals and groups that prevent their self-actualization and their ability to fully participate in our vibrant democracy. To forestall any violent upheavals and ensure the resilience of constitutional methods for expressing discontent, the state must remain committed to achieving equality and protecting its minorities. As Justice Subbarao presciently reminded us, a constitution is only permanent and not eternal. There is nothing to choose between destruction by amendment or by revolution. The former is brought about by totalitarian rule, which cannot brook constitutional checks, and the other by the discontentment brought about by misrule. If either happens, the constitution will be a scrap of paper. As former American President Barack Obama said in his farewell address at the White House on 10th January 2017, the most important office in a democracy is the office of the citizen. Enlightened citizenship requires people's participation in interpreting the Constitution, in imbuing it with meaning, in making it their own. Our Constitution, like others of its genre, is a mobilizational tool for social movements. Its values provide a unifying force in recognizing, acknowledging, and respecting our diversity and plural culture. It is a powerful moral register. The ability of the Constitution to inspire citizens' movements is unique. In doing so, it ensures that we cannot overlook the importance of citizen interpretive practices. The Constitution does not solely belong to lawyers and judges. The Constitution's aspirations and transformative vision transcend legalistic formulae and esoteric legal debate. The vision and aspiration of the Constitution is captured in its preamble. While the preamble is not legally binding, it performs a far more important task, that of imprinting into our constitutional consciousness the values of justice, liberty, equality, and fraternity. As long as we view the preamble as our guiding light and continuously strive to make its promise come alive, our country will remain firmly on the path of a constitutional liberal democracy. It is the people's engagement with the Constitution which breathes help life into the Constitution's founding creed. We, the people of India, do hereby adopt, enact, and give ourselves this Constitution. The people's faith in our Constitution's transformative potential has been made manifest in the way several marginalized groups have used constitutional vocabulary as a basis to seek empowerment and advancement. These groups include under-trial prisoners, bonded and migrant laborers, scheduled castes and scheduled tribes, women, members of the LGBTQ community, slum dwellers, pavement dwellers, and the disabled. They often seek extraordinary remedies. Their pleas for intervention challenge received conceptions of separation of power and call into question the distinctions between administration, legislation, and adjudication. As I shall argue in this segment of my presentation, however, it would be incorrect, both in terms of constitutional doctrine and social history, to regard courts as the exclusive avenue for the realization of legal entitlement and the attainment of constitutional aspirations. Let me be very clear. Courts do have a vital role to play in preserving liberal democratic values and in fostering a culture of constitutionalism. But the process of realizing constitutional rights is more complex than a lawyer's vision of legal strategies would lead us to foresee. Courts are but one actor involved in the constitutional project. A vital actor, yes, but one whose role must be understood. This having been said, let me now dwell briefly on the extremely important role that I do envision courts playing in furthering democratic values and a culture of constitutionalism. Justice Edwin Cameron of the South African Constitutional Court makes a perceptive observation when he says, if we accept the limited value of legal rights, if we accept that the law is an adjunct social instrument, that it cannot mend society, nor choose its pathways, and that its remedies and rhetoric should be approached with skepticism, then we may nevertheless be able to defend a modest role for it. The interaction between courts and social change is a much studied phenomenon. Lanny Guinier and Gerald Torres argue that a new statutory or judicially determined right alone is neither self-enforcing nor culture shifting. Rights alone are unable to offer us an enforceable set of policies or a vision for the better society. It is imperative, therefore, that a declaration of rights be connected with remedies as well as to the lived experience of those on whose behalf they are named. Well-organized social movements help expand the law's reach beyond the sophisticated legal grammar of formal fairness to the transcendent commitments of justice. When this happens, the language of law is stretched to accommodate the language of the people, especially those who act collectively to strengthen our democracy. This phenomenon is also captured by Richard Posner, a judge of the US Court of Appeals for the Seventh Circuit. Posner analogizes the change of view by courts to boiling the frog. The underlying idea is that if you put a frog into boiling water, it will jump at you immediately. But if you put it into warm water and gradually increase the temperature, you can boil it effectively. Worse still, if you throw both the judge and the frog into boiling water. The point is simply this. As a part of society, courts through their judgments serve as a prism through which the existing societal view on a given issue is refracted. Take the celebrated case of the American Supreme Court judgment in Obergefell versus Hodges, for instance, in which the court recognized that the same-sex couples have a constitutional right to get married. Justice Kennedy, who wrote the court's majority opinion, held that the nature of injustice is that we may not always see it in our own times. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. Absent appropriate social conditions, judicially driven social change may close off the possibility of a much more ambitious reform. Commenting on the judgment in Roe versus Wade of the US Supreme Court and its analysis of the woman's right to abortion, Justice Ruth Bader Ginsburg noted that the political process was moving, not swiftly enough for advocates of quick and complete change, but majoritarian institutions were listening and acting. Heavy-handed judicial intervention was difficult to justify and appears to have provoked and not resolved the conflict. In saying what I have, I do not intend to abnegate a constitutional court's counter-majoritarian role, far from it. Indeed, for discrete and insular minorities whose concerns are not addressed through the political process, courts may often be the only forum for the realization of their rights. Even if the legal recognition of rights does not change the immediate reality of those oppressed, It vindicates their struggles and provides them a sense of entitlement and belonging. As Oishik Sirkar has remarked, symbols of emancipation are not mere bourgeois vanity. They have real effective consequences. However, the point which I make is this: a clear-eyed assessment of the Supreme Court's functions, of the limits of what it can do, and of the constraints, doctrinal and procedural, that inform its functioning can help us ensure that as citizens, we channel our energies in seeking societal reform through multiple fora rather than just through the courts. Endowing courts with the expectation that they are the sole repositories of the project of bringing about social change is unrealistic. It will breed cynicism about unrealized hopes. This having been said, let me now share a few examples of cases that aptly demonstrate the vital role that courts can play in fostering the growth of constitutional and liberal democratic values. In cases and controversies brought to the court evidencing a deprivation of constitutional and legal rights, the Supreme Court of India has not just the power, but the mandate to interfere. Let me share two fairly recent examples with you from the cases of the Gujarat Mazdoor Sabha and the state of Gujarat, and B.K. Pavitra and the Union of India. In Gujarat Mazdoor Sabha, we had to rule on the legality of a notification issued by the government of Gujarat on 17 April 2020 during the pandemic. The notification, projected as a measure to deal with the pandemic and the financial crisis, had the consequence of increasing the upper limit of working hours for labor from 9 to 12 per day and from 48 to 72 hours per week, of shortening rest intervals and of halving the overtime pay. We struck down the notification and ordered that the workers should be paid back wages for their overtime work in exercise of the power given to us by Article 142 of the Constitution. Significantly, we noted that the basic rights of workers could not be reduced to mere paper tigers. We grounded the guarantee of working hours and the embargo on overtime in Articles 21, the right to life, and Article 23, the prohibition of forced labor in the Constitution. We held that the government's notification evidenced an intent to capitalize on the pandemic to force an already worn-down class of society into the chains of servitude. This case is a clear example of the court using rights as a benchmark to assess the legal validity of executive action and discharging its solemn obligation as a sentinel. While the Supreme Court must equally render justice to all those who appear before it, it is duty-bound, consistent with the scale of values enshrined in our Constitution, to exhibit greater sensitivity to those at the bottom of the social and economic hierarchy. In this role, the court has to act as an oversight body to ensure that executive action does not result in constitutional rights being sacrificed at the altar of market forces. As we noted in the judgment, the Factories Act attempts to neutralize the excesses in the skewed power dynamics between the managements of factories and their workmen by ensuring decent working conditions, dignity at work, and a living wage. Ideas of freedom and liberty in the fundamental rights recognized by the Constitution are but hollow aspirations if the aspiration for a dignified life can be thwarted by the immensity of economic coercion. The framers of the Constitution realized that to uproot caste-based inequality, the state intervention in the nature of affirmative action is indispensable. In B.K. Pavitra versus Union of India, we found ourselves tackling negative stereotypes against the merit and efficiency of the scheduled castes and scheduled tribes, their candidates, couched in the seemingly neutral language of law and legal argumentation. Underlying our judgment was the recognition that assumptions about efficiency and merit cannot be divorced from social and economic privileges that have accrued to the forward castes and the centuries of deprivation and discrimination suffered by the members of the scheduled caste and scheduled tribe communities. More concretely, in this case, we had to determine if the government of Karnataka's policy of granting consequential seniority to scheduled caste and scheduled tribe candidates was constitutionally permissible. In concluding that what was relevant was the satisfaction of the government as to whether there was inadequate representation for the reserved communities in the services under the state, we held that the principle of substantive and not formal equality underlay the Constitution's equality code. We also construed the idea of efficiency of administration in this light. We held that efficiency cannot be based on a stereotypical assumption that promotees from the affirmative action group of citizens drawn from the scheduled castes and tribes are not efficient, or efficiency is reduced by appointing them. We held efficiency of administration in the affairs of the union or the state must be defined in an inclusive sense, where diverse segments of society find representation as a true aspiration of governance by and for the people. If this benchmark of efficiency is grounded in exclusion, we noted, it will produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency is grounded in equal access, our outcomes will reflect the commitment of the Constitution to produce a just social order. To take yet just another example, a recent example, in the Hathras rape incident that shocked the conscience of the nation, the Allahabad High Court took suo motu cognizance of the incident and framed for its determination the following question: whether the economic and social status of the deceased family has been taken advantage of by the state authorities to oppress and deprive them of their constitutional rights. The matter being sub judice, it would be inappropriate for me to make any substantive comments about the case at this stage. However, I cite this example only to drive home the importance of judicial intervention as a bulwark against the exercise of state power that militates against the key principles that the culture of constitutionalism in our country is based on. In the same vein, social action litigation has served as a powerful tool to correct deficiencies in government delivery and to protect the interests of those at the receiving end of repression, administrative inefficiency, and absence of legal protection. In order to realize the full potential of this unique form of intervention which has been developed in India, public-spirited citizens need to determine how to bring forward petitions that are well-focused and narrowly tailored. To be more concrete, I mean litigation that is based on strong evidence and arguments that form the basis for seeking the court's intervention. Litigation that is based on broad stakeholder consultation and genuinely represents the voices of those on whose behalf it is brought forward. Only in this way can we persuasively counter the well-founded concern that social action litigation is being transformed from an instrument to empower the impoverished and neglected into a means to entrench and exacerbate existing social inequities. As Arun Thiruvengadam has argued, organizations pursuing social causes should be facilitated in developing a bottom-up litigation strategy so as to mark a return of the foundational roots of PIL. In fact, the foundational days of PILs, it was social entrepreneurs, far more than lawyers, who approached the Supreme Court pro bono with social causes. To realize the liberatory potential of PILs, judges and lawyers should play a facilitative role, with the focal point of the litigation being public-spirited petitioners and the constituency that they represent. For we must remember that it is their lived realities that PILs are principally meant to address. A high point of this form of social action litigation is the Nalsa judgment, which upheld the right of self-identification of one's gender and laid down guidelines to promote the rights of transgender persons. The judgment was a culmination of active participation from the constituency affected by state repression, which, it can be hypothesized, led to a beneficial outcome. There are examples also of locally and culturally rich movement involving demands of state-enforced rights. Litigation and call for legislative reform in such instances were accompanied by non-legalistic initiatives. In Tukaram versus State of Maharashtra in 1979, the Supreme Court had acquitted 2 rape-accused policemen because the victim did not raise an alarm and there was an absence of injury marks. The judgment created an uproar. 4 law professors, including the legendary Professor Upendra Baxi, my own guru, who is present with us today, had written to the then Chief Justice of India, criticizing the judgment. 4 years of sustained protest led to a change in the criminal law in 1983, which laid down the need to establish a woman's consent and raise the punishment in custodial rape cases. Another interesting example is that of the Dongriya Konds living in the peaceful and inaccessible Niyamgiri range, which is rich in bauxite. A refinery sought to exploit this resource. Stringent environmental regulations were violated in a bid to acquire the land without Dongriya's consent. On April 18, 2013, the Supreme Court gave a clear verdict that mining clearance can be only granted if the Dongriya's consent. This led perhaps to India's first environmental referendum, which required mobilization within the Dongriya community in 12 villages who collectively rejected the proposal. The tussle between indigenous populations who have for centuries owned and managed land, territories, and resources, and the market also exists in other jurisdictions. In Australia, the Aboriginals and Torres Strait Islanders have struggled for years to gain territorial rights and have engaged in battles with mining industry over resources. We need to respect the relationships of reciprocity and kinship that indigenous people have with their land. Their unchecked displacement and dispossession are a matter of grave concern. As the Supreme Court has observed, a development paradigm depending largely on the plunder and loot of natural resources, more often than not, leads to failure of the state, and that on its way to such a fate, countless millions would have been condemned to lives of great misery and hopelessness. A critique of judicial intervention that has recently begun gaining currency is that judicial review is unable to interrogate or dismantle existing societal conditions in which litigation is brought. In the context of human rights litigation concerning access to medicines, for instance, Amy Kapuscinski argues that such litigation does not prevent or help answer the question of why such medicines are profoundly expensive in the first place. She argues that litigation may in fact have a plausibly regressive net effect. This critique also applies to the inability of litigation to question social relations of capital, patriarchy, heteronormativity, ableism, and caste hierarchy. Further, not every citizen can make equal use of legally guaranteed rights. As the popular saying goes, there is far too much law for those who can afford it, and far too little for those who cannot. We must also remember that legal intervention is often necessary, but not sufficient. As Ratna Kapoor argues, while human rights are something that we cannot not want, they cannot give us what we want. Take the decision of the Supreme Court in Navtej Johar, for instance. While our verdict helped transform LGBTQ citizens from unconvicted felons to full and equal citizens in Indian democracy, they still face the prospect of prosecution under public nuisance laws. We have seen that in cases involving two women partners, the parents of one of the partners would accuse the other of kidnapping or abduction. The project for the realization of their full humanhood has just begun. The baton now passes to society in a long walkathon. Courts cannot just make broad declarations of rights without being cognizant of the practical implementation of their decisions or the unintended consequences that a decision might produce. This is not to say that judicial intervention should not take place in such cases. It is only to say that the court needs to be conscious of its institutional limitations. For judicial intervention that is not well thought out can have a counterproductive effect of setting the movement back. There are ways in which courts can make a meaningful contribution whilst being cognizant of their institutional limitations. It can set in motion a thought process for reform. It can adopt dialogic remedies. It can use social action litigation as an instrument to broaden the conversation and provide voice and representation to individuals and groups whose interests might otherwise be ignored in decisions impacting them. At the same time, the court can ensure that it plays a facilitative role without dominating the conversation in society. Richard Bellamy, in his celebrated book titled Political Constitutionalism, A Republican Defense of the Constitutionality of Democracy in 2007, notes that the increasingly dominant view is that constitutions enshrine and secure the rights central to a democratic society. According to this view, which Bellamy describes as legal constitutionalism, a constitution of this kind, not participation in democratic politics per se, offers the basis for citizens to be treated in a democratic way as deserving of equal concern and respect. Roberto Unger remarked that discomfort with democracy is one of the dirty little secrets of contemporary jurisprudence. Bellamy has launched a defense of political as distinct from legal constitutionalism. Criticizing the overarching importance ascribed to judicial review, Bellamy observes, far from guarding against a largely mythical tyranny of the majority, the checks imposed by judicial review on majoritarian decision-making risk undermining political equality, distorting the agenda away from public interest, and entrenching the privileges of dominant minorities and the domination of underprivileged ones. As such, legal constitutionalism can produce rather than constrain arbitrary rule, detract from the rights protection of weak minorities, and damage the rule of law in both the formal and the substantive senses of treating all as equals. In his view, democracy provides a form of political constitutionalism which is superior to legal constitutionalism or their devices that are proposed as constraints upon it. While I, as a judge, may not go as far as to accept the pristine thesis of Bellamy in rejecting the value of judicial review, and I don't accept that thesis, it does emphasize the importance of the democratic process in the working of the Constitution. For, as he says, the democratic process is both constitutional, offering a due process, and constitutive, which is able to reform itself. As former South African Constitutional Court Judge Kate O'Regan notes, courts can be forums for a reasoned debate on contested issues of social and public policy. Illustratively, in the Mazibuko case in the South African Constitutional Court, at issue was the question as to whether the government's free water policy was constitutional. She held that such litigation fosters a form of participative democracy that holds government accountable and requires it to account between elections over specific aspects of governmental policy. In conclusion, let me say that over the past 71 years, as a constitutional democracy, we have traversed a long distance. The terrain has been uneven. We have transformed the ideas of democracy and constitutionalism from foreign dressings on an Indian soil into something authentically and uniquely Indian. Our institutions of governance, albeit imperfect at times, have been transformed under the glare of public scrutiny. In 1997, Indian-American political commentator Fareed Zakaria wrote an influential essay in Foreign Affairs titled The Rise of Illiberal Democracy. Zakaria argues that democracy and liberalism do not inevitably go together. He highlights that what sustains democracy is not simply legal safeguards, but rules, norms, and practices, democratic behavior. After the mammoth task of drafting the American Constitution had been completed, some citizens asked Benjamin Franklin whether the form of government chosen by them was a monarchy or a republic. A republic, replied Dr. Franklin, if you can keep it. In this popular story is an extremely important message for us. Much as it is important for courts, the media, civil society, and vigilance agencies to exact accountability from the government and to ensure that the Constitution remains the guiding light in all that we do, it ultimately falls on each of us as citizens to participate in the slow but vital everyday task of transforming our Constitution from a charter of aspirations to a reflection of reality, and in ensuring that we continue to learn from our mistakes and keep the democratic spirit alive. As I have argued here today, in this project, courts and the law have an important role to play. In closing, I would like to share the reflections of judges from the apex courts of South Africa, the US, Canada, and Australia that speak to the importance of law in creating a better society. As Justice Cameron says, the law cannot offer transcendence from human toil and limitation, but it can offer us the chance to be better than ourselves, and that is surely something worth celebrating. In the same vein, Justice Ruth Bader Ginsburg has the following message for all young people about the power of the law. And she says, I would like them to have the enthusiasm that we had in the 1970s, determining that the law should catch up to the changes that have occurred in society, the realization that no one should be held back, boy or girl, because of gender, artificial gender barriers, that everyone should be free to be you and me. Justice Beverly McLaughlin, the former Chief Justice of Canada, says, like every other human institutional endeavor, justice is an ongoing process. It is never done, never fully achieved. Each decade, each year, each month, indeed each day brings new challenges. Finally, Justice Michael Kirby, the great friend of India that we have, says, law is not just an ordinary occupation. It is not a mechanical job. It is a vocation committed to justice. It is one fundamentally dedicated to the principles of human dignity and human rights. We cannot always deliver on the promissory note to that effect. Sometimes, indeed, the check is dishonored by Australian law. But as lawyers and citizens, we have choices. And when it is possible and lawful to do so, we should take the path of justice and equality. Today, I've tried to emphasize the vital role that each of us can play in contributing to deepen and broaden the reach of our Constitution's empowering vocabulary in avenues inclusive of, but not focused exclusively on our courts. The framers of our Constitution laid down the cornerstone to create a legal and institutional infrastructure to promote a culture of constitutionalism and liberal democracy. It now falls on each of us to play our part in ensuring, to paraphrase Dr. Franklin's remark, that we keep it that way. Thank you very much for giving me this opportunity, Professor Raj Kumar. And thank you, Professor Baxi, for joining us and for listening to me this morning, and to all of the participants at this Constitution Day lecture. Thank you very much.
Thank you. Thank you very much, Justice Chandrachud, for a fascinating tour de force on the evolution of the principles of constitutionalism, liberal democracy, and indeed enlightened citizenship. I would like to express my heartfelt gratitude, deep appreciation for Justice Chandrachud for having taken time on a regular court day to actually come early and deliver this lecture. I would immediately request Professor Upendra Baxi, who does not need any introduction, but more importantly, besides being a great scholar of jurisprudence and constitutional law, has been one of the world's great public intellectuals in the field of law and beyond, to share some of his reflections on the Constitution Day. Professor Baxi, over to you.
Thank you, Raj, and greetings to all the colleagues who assembled today at this conference. This is a very unusual law day. It occurs during two major events of life, both of which threaten human existence and perhaps civilization, namely Anthropocene and what we are more familiar with immediately, COVID-19. And in this context, to hear Dr. Justice Chandrachud is a sheer pleasure. And then I have an extended footnote from Ambedkar, from Raj Kumar. It's a feast of ideas, and I do not wish to, I cannot possibly add to what you said. Excepting when you hear Dr. Justice Chandrachud, you take two takeaways from what he has said. It is for me. One is how a progressive judiciary can empower enlightened citizenship. I think that's a wonderful message and elaboration in his talk, which we should all read carefully. And second, following on from what you said, Raj, is the question of a false choice. And enlightened citizenship must reject two false choices. One, choice between political authoritarianism and human security. And second, as Justice Chandrachud indirectly said, between judicial despotism and enlightened citizenship. Both are false choices, and one has to progress to the notion of enlightened citizenship in a way that avoids this danger. And I think it's been very well said. I will make about 3 points, and then when my time is up, you tell me. And I shall do them very briefly. Talking about both climate change and COVID and the relation between the two, our Supreme Court has done wonders, and so have the 19 high courts in dealing with COVID situation, as we all know. And more strength to their elbow, because then we need both the courage of conviction and a sense of balance in dealing with the issues of right to health, public health, and collective security. And they have shown how this is done. It's very important that we're doing that. I, first of all, assume that we know all that is been known about COVID. I doubt whether we know, or we can equally safely assume that we know all that we should about Anthropocene. In fact, Anthropocene and COVID present to us differently though. In short term, one in short term, one in long term, but a common threat to human existence, which I would like to call as jurisprudence of extinction. Both COVID and Anthropocene bring to the doorstep threats to collective and individual life and to enlightened citizenship. And these threats have to be abiding in one case, that is of Anthropocene. Perhaps less so, I hope, in COVID. We know facts about Anthropocene and number of greenhouse gases, global warming, glaciers melting, vanishing species and ecosystems, Amazon fires, climate refugees, longer carbon footprint, erosion of tank and subterranean water, changes in stratosphere and biosphere. We know all that. We also know that 97% of scientists agree that there is something called anthropogenic harm, and it is steadily increasing hour by hour since 1950. And therefore, there is agreement among scientists as to the fact of this harm occurring. There is difference of opinion on measurement and models, and the difference of opinion is significant, but is confined to 3% of scientists, and that's important. What is most unfortunate and completely avoidable is climate change denialism. That such a phenomenon as climate change has at all happened. This denialism is, I believe, a crime against humanity and should be proclaimed as such, because it is furthering and promoting jurisprudence of extinction. This second crime against humanity, which we should all develop, help develop, is the environmental authoritarianism. That the state alone or the leader alone can fulfill the task of collective human security in the face of Anthropocene is wholly and egregiously erroneous. It is the task of governments and people together to fight this extinction of species and extinction of human life. And therefore, authoritarian environmentalism is also a crime against humanity, which forbids making security as security risk the idea of dissent or free speech, or which criminalizes difference, human difference, which is unavoidable in human society. And thirdly, we should also try freely to declare, as a group of responsible citizens everywhere should declare a new order of relationship between global business and global human life. And the present corporate Neanderthalism should not anymore rule us. It should in fact be declared as a crime against humanity. How far legal research and legal education can promote a milieu in which these crimes against humanity are developed and concretized is, I think, a task heavily before us. I will now turn to what is to be done and where do enlightened citizenship comes in and end with that. In a sense, both COVID-19 and Anthropocene speak to what the Ghanaian thinker, the great Ghanaian thinker, Claude Aki, I think his name was, in 1994, he wrote a book called The Democratization of Disempowerment. He talked about Africa, but both COVID and Anthropocene have brought this to our notice very sharply now and for the whole world. How are these to be dealt with? And I'll go back to one man, one person only, and that chap is called Mohandas Karamchand Gandhi. I find Gandhi, we all find Gandhi as a politically ambiguous name, last name, so I avoid the word Gandhi. Karamchand I avoid because, as I often said, it is appropriated by television espionage serial. So we're left with Mohandas. So I call simply Mohandas and Mohandas Jin. So Mohandas said three things which are relevant. With this I end. One thing he said, that we must think about, we must link always, we must realize the connection between always global citizenship and enlightened citizenship of democracy. In other words, we can't be citizens of a nation or a society without at the same time being citizens of the world. And he said he learned this from his illiterate grandmother. The grandmother has a great role in human life. He also said, as you no doubt know, secondly, that the world is a huge family, ancient Indian notion of Vasudhaiva Kutumbakam. And he also said, thirdly, and that's my last point, and he said, very simply, he said, be the part of the change you wish for. There is not enough. There is enough for human needs, he said, but there is never going to be enough for human greed. So neither the ease of doing business index or the great happiness index, national gross happiness index, or transparency and accountability index, all the indices, none of these will enable us to fight extinction. What we need is a return to Gandhian thought and action. And he was the pre-industrial critic of industrial civilization. And he is the pre-Anthropocene critic of the Anthropocene. And that, I think, with which I must now end, because Professor Patnaik has to say a few words. But my time is up, but I do say what we need is ancient wisdom to fight modern menaces like Anthropocene and COVID. And what does that wisdom consist? It consists, if I may place it in a Baxi moron, it consists in the need to be aboriginal rather than original. The greatest challenge before legal education and legal research is to stop being original and to start being aboriginal. Thank you very much, Raj. Thank you.
Thank you. Thank you so much.
Thank you very much, Professor Baxi, for that truly insightful presidential address. Ancient wisdom to fight modern menaces. That is beautifully put. And thank you for putting the conversation in the context of this jurisprudence of existence, as you put it, with the threat of Anthropocene and COVID, and this environmental authoritarianism as a crime against humanity. So thank you very much. Thank you very much for that truly insightful presidential address. What I take away from that address, Professor Baxi, is something that Honorable Justice Chandrachud also has highlighted in his address, is that be the part of the change that you wish to see. And perhaps that brings us back to the question that Justice Chandrachud raised at the very beginning of his talk, is that how do we as citizens ensure that provisions of citizenship are ensured? And it actually brings me back to Dr. B.R. Ambedkar, who, as Professor Raj was talking about his speech at the Constituent Assembly, and he, in the same speech, actually put the responsibility squarely on the shoulders of we the people. He said it is a responsibility of the we the people to create a compassionate society. He said, with the British gone, we have no longer have anybody else to blame. It is our responsibility. And while we do recognize that India in the past 71 years, have been treading a rough path, battling social, political, economic inequalities on one hand, and this dream of liberty, equality, and fraternity as enshrined in the Constitution on the other, I think going back, the responsibility again falls squarely on our shoulders as citizens, as students of law, to take this mission forward. With that, I would like to extend my heartiest gratitude on behalf of OP Jindal Global University to Honorable Justice Dr. D.Y. Chandrachud for joining us, for accepting our invitation and delivering the Constitution Day lecture. We are truly grateful for your presence here with us today. Thank you very much. A big thank you once again to Professor Upendra Baxi. Thank you for always being there and mentoring us, guiding us, and infusing us with new ideas. A heartiest thank you to Professor Dr. C. Raj Kumar, our founding Vice-Chancellor, for his constant support, guidance, and mentorship. With that, we conclude this Constitution Day lecture.